America's highest court handed down a landmark verdict today.
The Supreme Court has limited federal judges from blocking the president's policies nationwide.
The Supreme Court was examining this fundamental issue regarding whether a district court judge possesses the power to obstruct the policy and his agenda.
The justices have decided whether a federal judge can issue nationwide injunctions.
The Supreme Court typically unveils its most closely watched decisions across multiple weeks or days. Not this year.
Okay. Put everything on hold immediately, because what I'm about to guide you through represents truly one of the most consequential Second Amendment advancements in contemporary American history. A federal appellate court just issued an 87-page opinion that doesn't merely create openings and carry prohibitions, it obliterates the complete legal infrastructure that firearm restrictive states have depended upon for generations. And the most volatile component of this ruling, the element that has gun control groups panicking behind sealed doors and complete emergency mode, is concealed deep within the historical examination, where these jurists tracked weapons rights all the way back to 1328. That's right, medieval England. What they discovered there establishes a sequence of legal precedent, so indestructible, that restrictive states basically have no alternatives. But before we reach that, there's something even more destructive tucked away in this ruling that hardly anyone is discussing yet. And it carries the capability to nullify thousands of weapon-free zone statutes throughout the entire nation in a single action. So let's dissect this entire matter section by section, because every firearms owner in America must comprehend what just occurred. Allow me to establish the context for why this specific ruling stands apart from every other judicial triumph we've commemorated over recent years. This isn't some limited technical victory on a procedural matter. This isn't a jurist declaring one particular clause of one particular statute goes marginally too far. What transpired here is that a three-judge federal panel took an entire state's residency-dependent carry licensing system and pronounced the complete thing unconstitutional. The whole structure eliminated, and they didn't accomplish this through some inventive legal argument that could be readily reversed. They achieved it by constructing the most exhaustive historical argument for the right to bear arms in public that any federal tribunal has ever compiled. We're discussing a decision that follows an uninterrupted chain of legal safeguarding for armed self-protection across nearly 7 centuries of Anglo-American jurisprudence, from the Statute of Northampton in 1328 through colonial charters and founding-era deliberations through Reconstruction and directly to the current day. Judge Catherine Polk-File composed this judgment, and what she crafted isn't merely a court decision. It's essentially a comprehensive lesson in constitutional history that leaves anti-firearm legal academics with no escape. Now, here's where matters begin becoming truly captivating, and this is the portion that gun control proponents were hoping no tribunal would ever uncover. The jurist didn't merely examine what historical administrations did regarding regulating weapons. She examined what they intentionally elected not to do. This is a legal method called negative historical proof, and it entirely reverses the approach on how Second Amendment cases have been contested. You see, ever since the Supreme Court's Bruen ruling, the government has been obligated to demonstrate that any contemporary firearm restriction aligns with America's historical tradition of weapons regulation. So, what anti-firearm states generally do is excavate some forgotten 2-century-old law and brandish it as evidence that the founders were completely comfortable with firearm control. But Judge Fale inverted that entire approach. She examined periods of colonial conflicts, frontier settlement, civil disorder, and documented public safety crises, and she uncovered something extraordinary. Even amid the most perilous and turbulent periods in American history, administrations specifically and intentionally declined proposals to limit the carry rights of travelers and non-residents. They possessed the chance, they possessed the rationale, and they still refused. That generates a historical documentation that is absolutely fatal to the government's stance, because if the founders wouldn't limit carry rights even during armed conflict, how can contemporary politicians rationalize doing it during peaceful times? But it becomes even more destructive than that. The tribunal documented 23 distinct historical instances extending from 1690 through 1868, where administrations were presented with chances to prohibit public public carry and explicitly elected not to. 23 occasions, and in every single instance where historical administrations did enforce some form of regulation on bearing arms in public, they executed it through objective shall-issue type systems. Never once through the sort of discretionary may-issue arrangements where some administrator gets to determine, based on their individual sentiments, whether you merit exercising a constitutional right. This discovery alone annihilates the legal approach that states like New York, California, New Jersey, and others have been operating for generations. Their entire methodology has been constructed on the presumption that discretionary licensing has profound historical foundations. This tribunal just demonstrated it, hasn't it? Never did. The entire matter was a legal fabrication. And speaking of legal fabrications, let me inform you what the tribunal stated about so-called sensitive locations, because this is the portion that will generate tremors through every state legislative body that's attempted to prohibit firearms from public areas. After the Bruen ruling was issued, anti-firearm states believed they discovered the perfect escape route. If they couldn't prohibit carry completely, they'd simply designate every square foot of public area a sensitive location where firearms are forbidden: airports, public transportation, parks, eateries, cinemas, medical facilities, walkways near schools, walkways near government structures, basically anywhere a human being might actually be present. Some jurisdictions were literally attempting to classify 95% of their public land as prohibited to lawful carry, which effectively recreated the carry prohibition they'd just been informed was unconstitutional. The tribunal saw directly through this and destroyed it with one devastating piece of historical examination. The jurists discovered that in the founding era and throughout the 19th century, there were precisely 4 classifications of locations where carry could be historically limited: legislative assemblies while they were convened, courthouses during active proceedings, voting locations on election day, and educational institutions. That's the complete inventory of 4 classifications. Everything else, including houses of worship, marketplaces, public assemblies, government structures, and even powder storage facilities, was permissible for lawful carry. So, when contemporary states attempt to designate shopping centers and public parks as sensitive locations, they're not following historical tradition. They're creating restrictions that possess zero foundation in the constitutional documentation. But here's the legal explosive device buried in this section that most individuals are entirely overlooking. The tribunal ruled that even in those 4 legitimately sensitive classifications, the government cannot enforce comprehensive prohibitions on firearms. Instead, they're required to employ what's called the least restrictive means available. That means elements like secure storage alternatives at the entrance, temporary surrender protocols, or specific exemptions for trained license holders. This single requirement is going to nullify thousands of weapon-free zone statutes across the country, because virtually none of them employ the least restrictive means. They all simply post a sign that says no firearms and declare it constitutional. Under this ruling structure, that approach is legally deceased. Now, let's examine the constitutional framework of this ruling, because this is where the legal brilliance truly illuminates, and it's the portion that makes this decision nearly impossible for anti-firearm tribunals to circumvent. Judge Fail didn't merely depend on one constitutional clause. She interwove 3 separate doctrines into a unified legal examination that firearm restrictions must satisfy, and it's an examination that virtually no carry prohibition can withstand. First, there's the text, history, and tradition examination from Bruen. Requiring the government to prove any restriction corresponds with America's historical firearms tradition. Second, the tribunal applied strict scrutiny under the Equal Protection Clause because residency-dependent license denials create unconstitutional categorizations that treat Americans differently based exclusively on where they reside. And third, the tribunal invoked the anti-commandeering doctrine, which prevents states from employing local regulations to effectively invalidate federal constitutional rights. Each of these examinations individually is extraordinarily challenging for firearm control laws to survive. Combined into one unified framework, they create a legal obstacle course that is essentially impossible to complete. The equal protection perspective is particularly ingenious and deserves special recognition because of how it transforms the strategic terrain. By ruling that residency requirements trigger strict scrutiny, the tribunal provided Second Amendment proponents a second, powerful constitutional tool. Even activist jurists who personally abhor firearm rights find it nearly impossible to dismiss an equal protection claim. The principle is direct and deeply embedded in American jurisprudence. If you furnish a right or service to residents, you cannot withhold it from law-abiding non-residents. Period. The jurist identified what legal academics are now terming constitutional dead zones, geographic regions where fundamental rights simply disappear when you cross a state boundary. And she made a point that is devastatingly straightforward. You don't forfeit your First Amendment right to expression when you drive from New Jersey to New York. Your Fourth Amendment protection against unreasonable searches doesn't disappear because you're visiting from another state. So why has the Second Amendment been treated as an inferior right for over a century? The tribunal found that these residency-dependent systems violate the Privileges and Immunities Clause of Article 4, Section 2, a provision specifically crafted by the founders to prevent states from establishing second-class citizenship for out-of-state Americans. This is a constitutional clause that most individuals have never even heard of, but it was placed there for precisely this circumstance. Allow me to tell you about the domino effect that's already in motion, because the velocity at which this ruling is spreading through the legal system is unprecedented. Within 72 hours of this decision being published, Second Amendment advocacy organizations filed 17 new federal lawsuits across 6 different states, all citing this ruling as direct precedent. Attorneys in California, Hawaii, New Jersey, Maryland, Connecticut, and Massachusetts are incorporating Judge Fail's arguments directly into their own submissions. California alone is now confronting 5 separate new challenges to its concealed carry licensing system, including one that specifically targets the state's good moral character requirement, which this tribunal labeled an unconstitutionally vague standard that encourages discrimination. Hawaii's entire May issue framework is under direct legal attack, with attorneys essentially duplicating the successful arguments. Wholesale and state attorneys there are reportedly indicating they may not even present a defense because this ruling makes their position legally indefensible. The tribunal established what legal authorities call persuasive authority, meaning even tribunals in other circuits that aren't technically bound by this specific decision are likely to follow its reasoning. Because the historical examination is so thorough and well documented that departing from it would practically guarantee reversal on appeal, federal jurists in other circuits are already citing this case in preliminary rulings, signaling that they find the constitutional examination compelling. So, what does all of this signify for you personally right now? Today, if you're among the millions of Americans residing in a restrictive state, this ruling provides you the legal framework to challenge virtually every aspect of your state's discriminatory carry laws, from license requirements to sensitive location prohibitions to ammunition regulations. The constitutional roadmap is now drawn. If you travel for employment or family or leisure, this decision potentially opens up states that have been inaccessible for decades. For the first time in a generation, there's genuine legal recourse against the patchwork of confusing, contradictory laws that have transformed law-abiding citizens into accidental criminals. And even if you reside in a constitutional carry or shall issue state, this ruling fortifies your position by creating constitutional barriers that will be extraordinarily difficult for future legislators to overcome if political currents ever shift. The historical examination in this decision essentially secures protections that extend beyond any single election cycle. There's also a psychological transformation already occurring on the ground. Law enforcement and prosecutors in restrictive states are beginning to recognize that aggressive enforcement of carry restrictions is going to result in costly federal civil rights lawsuits they're almost certain to lose. We're already observing prosecutors in some jurisdictions quietly declining to pursue charges in cases that would have been automatic prosecutions just a year ago. The enforcement mechanism is beginning to fracture because the individuals operating it can read the legal writing on the wall. What this tribunal has accomplished is validate what millions of firearm owners scholars have been stating for years that most firearm control laws are constructed on politics and fear rather than constitutional jurisprudence, historical precedent, or genuine public safety evidence. The jurists didn't merely reject the government's arguments, they systematically dismantled them employing the government's own historical sources and its own crime data, proving that these restrictions were never justified in the first place. The question is no longer whether the remaining restrictive states will collapse. It's when, and based on the velocity of the legal domino effect we're already witnessing, that timeline is much shorter than anyone anticipated. This ruling is the master key. It provides the constitutional framework, the historical evidence, and the legal strategy template for challenging carry restrictions from coast to coast, whether you're in a free state or currently behind the lines in a restrictive one. The momentum is undeniably on our side. We are observing the demolition of a century's worth of unconstitutional overreach happen in real time, and it is accelerating. I want to hear from you down in the comments. Which state do you believe collapses next? Is it California, Hawaii, New Jersey? Drop your predictions below, and if you want to remain on top of every major Second Amendment development as it emerges, make sure you subscribe to Weapons Law Advisor. And don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.